rise. The Court of Appeals Division 1 is now in session.
Thank you all. Please be seated. This is a time set for oral argument in Barlow versus Arizona Peace Officer Standards and Training Board, our case number CACV 190378. Each side is allocated 20 minutes for oral argument. If appellant wishes to reserve a portion of that time for rebuttal, you're free to do so, but you need to keep track of your own time at the clock at the podium. I would ask those in attendance to make sure your cell phones are off so that our presentation by the attorneys isn't interrupted out of deference and respect to them and to avoid any embarrassment if the phone were to go off. We have reviewed the record. We've conferenced the case. We're familiar with your briefs. We'd encourage you to keep that in mind as you do present oral argument. Also, when you present yourself at the podium, please do state your name and the party that you represent, given that the proceedings are being recorded for others to view as well. With that, Mr. Barlow, Mr. Barlow, you may proceed. Sorry.
Matt Barlow representing Taylor Barlow, the appellant in this case. I really only have two main points that I want to point out here. And the first is the proposed order of denial is really confusing and it's unclear. There's really no basis for the denial, at least that's not what they said. The motion to deny did not even mention the charges. That's the first thing I want to state. And then the second thing, which is the main point, is that Post did not follow their rules when it comes to this particular action. For these particular charges, Rule R13-4-105A states what meets what's the minimum qualifications, and then there's conduct that would disqualify an applicant within A. And A clearly states that it is subject to the exceptions of C and D.
Isn't there a difference between possessing marijuana and selling it? Isn't selling it clear?
What you have in 105A is you have, I believe it's items 6 through 19, which shows disqualifying conduct. But nowhere in the rule does it state that those particular points of conduct are not subject to the exceptions, because it actually specifically says that they are. It says, except as provided in subsection C and D, an individual shall meet the following minimum qualifications. So the sale of marijuana would still fall under those exceptions, and would still be you'd still allow the marshal's office to file the petition to see if that particular charge would qualify for the exception.
Well, even if it's true, then doesn't that make it discretionary?
Is everything discretionary? I mean, if you turn around, you can turn around and have all types of conduct through there, and we can say, is it discretionary? Well, it's still subject to the exceptions, and it's specifically outlined on how that is supposed to go.
Well, but maybe my point is, even if you would meet an exception, it's still discretionary with Post, I believe.
As long as they consider all of the exceptions within the petition, but they were specifically instructed not to file those petitions. And those petitions go before the board members so they can see all the mitigating factors. They were not allowed that.
So, could Post have been justified based on your client's sale of marijuana to deny him certification?
Can that happen if you don't follow any rules? Yes, that can happen. If you don't follow the rules, I mean, any conduct can really fall within those borders, and then they can just say, well, we don't have to apply the exceptions. Is what happened here. Then if you don't need to apply the exceptions, why are they in there?
Is your argument, though, I want to make sure I understand this, that the sale of marijuana did not give post discretion to deny the request?
Well, even using marijuana one time in the age of 15 still gives them discretion.
Okay.
They can use discretion on everything, but this is why you have these petitions
Well,
by the hiring agency.
Well, I guess my question is, if Post has a discretion, how did it abuse its discretion, and how do we, as the appellate court, review the allegation, I guess, of abuse of discretion?
If you turn around and take Rule 103G of their rules, they can use discretion on any applicant. It wouldn't even matter. They can just pick and choose whoever they want at that point.
I want to walk you back in the reg to where you started, which is to say that Post does have the discretion to certify an applicant who has illegally sold marijuana. As I read 13.4.105A, it says that the individual shall meet, in other words, must meet the following minimum qualifications. 9 says not have illegally sold marijuana. Now, what you're saying is that 105C allows Post the discretion to look past that?
It does.
Why? How can you say that when C specifically allows that discretion in the case of a prior illegal use of marijuana, but doesn't say anything about prior illegal sale of marijuana?
You can take that language, but you also can turn around and take the language of 105A, which says that all of these minimum qualifications are subject to C and D.
But C doesn't say use. C says use, but it doesn't say sale.
You can turn around and go into each one of those exceptions and say, well, they don't apply to here, here, and here, and here, but they didn't say that. They said all of those are subject to C and D, even if it does say use, but because we're talking about the sale, which I will go back to that, they don't have substantial evidence that there was a sale, because his reason to even have the marijuana was to use it for an experiment, and then he changed his mind.
And sold it.
Even the ALJ even said that even with that, under 103G, if he was certified, it wouldn't compromise the public trust in law enforcement had he been certified. But if you turn around and take that, I'm just saying, if you turn around and say, yes, okay, here the sale did happen, it's still subject to that exception, because it was still under use, because under subsection C.
C.
Yes.
I just don't see that. I mean, statutory interpretation, if the statute calls out specific items and does not refer to others, how can we construe it to include the others?
Okay, if we turn around, let me just back up a little bit.
Okay.
If we have the rule, and then we have each minimum qualification under that rule, here's your exceptions. Let them apply the exceptions. Let's see if they turn around, petition the board, look at all the mitigating factors, let the board determine that. But Taylor didn't even get that opportunity. I mean, if they think that they have substantial evidence, there's no problem with the petition going before the board. Here's all the mitigating factors, and let them decide.
Your position, if I understand it, is that 105C, which references use but not sale, would apply to sale as well? Is that?
I do. Yes.
Is that because you believe the evidence is sufficient?
I do believe the evidence isn't sufficient, because the one thing that you have to do is still apply the exceptions, because the appointing agency has all of that information. They're the ones that actually draft the petition, so they have all the mitigating factors to show everything.
But that's for the sufficiency of the evidence is for Post to decide, correct?
It is for posting the site, but I believe it's all been brought to their attention, and a lot of it wasn't brought to them following their own rules.
So if Post disagrees with you, believes the evidence is sufficient, then the argument fails?
Then we can turn around and they can turn around and pick and choose whatever applicant that walks through that door. They don't even have to follow the exceptions or the petitions or nothing. There's no reason for them to even be in there.
Can I follow up on Judge Howe's question in mind on the 105C application? Are you arguing, and it's and or, right, that there wasn't sufficient evidence of a sale and therefore 105C applies, or that 105C applies even when there is a sale, although the reg doesn't use that phrase, or both?
I agree that it is both, that would still apply even if it was a sale. But I believe that they don't have enough sufficient evidence that there was a sale. I guess we really got down to where we needed to go. If you have any more questions, I'll reserve the rest of my time for anybody unless you have more.
Very well. Thank you.
All right, thank you.
Mr. Hargrave.
Thank you. Good morning. May it please the court, Seth Hargraves, Assistant Attorney General on behalf of the state, representing the LE, Arizona Peace Officer Standards and Training Board, or AZ Post for short. The state would ask this court to affirm the Superior Court's decision upholding Post's denial of peace officer certification to Mr. Barlow for failing to meet the minimum qualification for certification that he had not sold marijuana.
The sale end with the issue, the fact that it was a sale, does that end the issue as far as Post is concerned?
Correct. After the administrative hearing, the order adopted by the board found that he had failed to meet minimum qualifications because he engaged in the sale of marijuana, even though it was one time. That is failure to meet qualifications and grounds to deny under the board's regulations.
Your friend makes an argument that the evidence was insufficient on sale. How does that into our analysis?
Well, it's the state's position that substantial evidence exists to prove that sale. If you look at the record in this matter, the hearing exhibit states Exhibit 3, which is Index of Review number 37, was his application to the Utah Post. He had been certified in Utah, tried to come in by waiver to Arizona. In that application was actually an addendum. He disclosed that in the year of 2008, his friend and himself were sold an ounce of marijuana. He had never done drugs, so he sold it to his cousin who did use drugs and wanted the marijuana. Also on his State's Exhibit 2, Index Review 35, his first application to AZ Post in August of 2016, he answered yes to the question, have you ever sold, smuggled, or transported marijuana for sale or personal gain? He disclosed that he had purchased marijuana in Salt Lake City, Utah, drove home to Arizona, sold the marijuana to another man, and in signing that application, he certified the information was true, complete, and correct. He also underwent a polygraph examination as part of his background for certification with AZ Post. In a pre-examination questionnaire, and again, that would be State's Exhibit 4 at the hearing, Index of Review 38. In that pre-exam, he acknowledged having previously bought, sold, or traded for marijuana. During the course of the discussion with the polygrapher, he indicated that he had purchased an ounce of marijuana for $20 to $50 in Salt Lake City when he was 18 or 19 years old in either 2008 or 2009, transported it back across state lines to Arizona where he sold it to a friend for about the same money, making approximately $20 to cover the cost of fuel. He was very specific in that, having sold and actually making a profit on his resale. You also have an email that he sent to AZ Post staff in December of 2016. That would have been hearing Exhibit 6, Index Review number 40. In that email, he indicated that when he was 18, they were in Utah, decided to experiment with marijuana. While driving home, they changed their mind. Their co-renter overheard the discussion and decided to purchase it from him. Now, he went on talking about how it would be unfair that under the board's regulations, if you engage in this conduct before the age of 18, you can qualify for juvenile indiscretion, but if it happens afterwards, you don't. And he kind of lamented that his errors with the marijuana didn't occur 10 months earlier, so he could qualify. So again, in that email, he's acknowledging to staff that he did in fact sell the marijuana. Then we have the second application with AZ Post, which was State's Hearing Exhibit 13, Index Review 28. Again, on that one, he answered yes to the question, have you ever sold, smuggled, or transported marijuana for sale or personal gain? Now, he has several admissions and documentation as part of the AZ Post application process. The board issued a note, initiated proceedings to deny based in part on that conduct, and Mr. Barlow requested a hearing. At that hearing, as the applicant, he had the burden of proof to demonstrate that Post allegations were incorrect. Now, at that hearing, he made the conscious decision not to call any witnesses. Now, the state called Mr. Barlow to testify. At no time in his testimony did he say that he did not sell marijuana. At time did he indicate that his previous disclosures were in error. Made no mention of it whatsoever. Nor did he call any witnesses to dispute the board's claims that he sold marijuana. He had the burden, he failed to meet it, which the ALJ found. Now, there's also the issue, it's the state's position that substantial evidence does support the fact that there was a sale of marijuana. And actually, the administrative law judge, in the conclusion of Law 13, acknowledged that his wavering on that issue was not credible. He just didn't find Mr. Barlow to be credible when he's saying that maybe he didn't sell.
What do you make of the ALJ's kind of funny comment at the end about, well, on the other hand, if Post wants to revisit that, it certainly can.
Well, I think what he commented there, I believe was the footnote, was that if the board finds that there's not substantial evidence to show sale, they may want to consider these other things. But the board did find that there was substantial evidence to show a sale. So there was no need to go into and look at the juvenile indiscretion for the other matters.
In reliance on the ALJ's finding credibility, the board decided that, yes, he was credible originally when he said, I have sold marijuana.
Correct. He had done it several times in several different documents, and even with the polygrapher. There were several admissions before finally changing his story after being told that it would be a disqualifier in Arizona.
Yeah. So the only meaning or the only significance of that footnote would be if the board decided, based on its review of the evidence before the ALJ, that he had not sold marijuana.
Correct, and that's not what the board did. The board determined that he had sold marijuana based upon the record. And
Counsel, let me ask you, is it I want to get back to the discretion issue, is it your position that under the current regulations applicable here, that for a sale of marijuana of any amount by someone who is 18 years or older, AZ Post would lack the discretion ever to grant a request like this one?
well, under their regulations, there is 103, I believe it's 103C, that says an applicant is required to meet the minimum qualifications. Under 105A, it says that unless it meets one of the exceptions, they must meet all the qualifications under 105A. Now, the exceptions here are C and D. C deals with the use or possession of marijuana. It goes down to a lot of detail, specifically in subsection C, about what would need to be shown, and they all address specifically use and possession. They do not address sale, which the ALJ found, which the board found. It's the state's position that C is not applicable whatsoever to this situation because we're dealing with a sale, not use or possession. Now, subsection D has another exception for juvenile indiscretion. Now, that one's not limited to just sale, use, possession. It applies to everything under actually 109A, which would include everything under 105. Under that criteria, anything that would potentially be disqualifying could be considered, could be somewhat waived if it meets the exception. Right. And under that rule, there are 6 very specific criteria, all of which need to be met. The first one, I believe it's 105D2A, is that the person was under the age of 18.
Right.
Second was that it had been
And
more than 10 years since the offense. In this case, he didn't meet those qualifications because based upon what he submitted, he was 18 or over, and it had been less than 10 years. So,
and forgive me for, let me try to ask a better question. How about that? It's hypothetical. It's not this case, because we know what happened in this case. The question is whether that was righteous or not. But in a different case, if I hear your argument right, AZ Post, for a marijuana sale by somebody 18 years or older, AZ Post would have no discretion to grant a request. Is that your argument?
under 105 and 109, they do not. There is a provision under 103G where they could waive. They did not do so in this case. So it's not under 103, 105, 109. It is a bar, the way it's worded. If you don't meet these minimum, you don't qualify. There are, under 103G, the board could consider. That's not in the record. That wasn't alleged below that they should have exercised that, and they decided they didn't take that up upon themselves. And 103G doesn't deal with a party petitioning for that consideration. That deals with the board on their own could consider that. They didn't do so in this case.
So let me just see if I can play this back correctly. Under the provisions that you would submit are at issue, there was no discretion. 105G, 109G, I'm sorry. 103G might provide discretion, but that's not applicable here.
Correct.
Okay.
Why isn't it applicable? It says, because I happen to have Westlaw here, the board may waive in whole or in part any provision of this article upon a finding that the best interests of the law enforcement profession are served and the public welfare and safety is not jeopardized by the waiver. What must happen in order to trigger that consideration by the board?
They can consider that on their own. They didn't do so in this case. Under 105C and D, it requires a petition on behalf of the applicant. 103G doesn't include that. That basically the board on their own, in consideration of everything, they chose not to exercise that discretion.
Do we know that from the record, or do we just know that by implication that it applied 105 instead of 103?
Off the top of my head, I don't know specifically in the record where that was addressed. I know the argument, it was addressed by, in the Superior Court, the judge addressed that in her decision that the board did not exercise that. But as I stand here, I can't point to a specific portion of the record other than the Superior Court's decision. And there was something that was addressed in counsel's reply brief about as far as the issue of whether or not the board considered the exceptions. If you look at the record, the board absolutely did consider the exceptions in this case. At their December 2017 meeting, when they considered his application and voted to initiate proceedings to deny, they discussed and considered these exceptions. They considered the applicability of the juvenile discretion exception in relating to the sale of the marijuana. They discussed the disqualifying nature of the sale and his age, which would have taken the issue out of consideration. And it's index review number 46, pages 4, line 20 through 25, page 6, line 3 through page 7, line 2, page 8, lines 1 through 11. And also at that meeting, some of the information they had in front of them was what was index review 20. It was a background investigation report from Colorado City Marshal's office. Now, counsel is arguing that that's a background investigation, that's not a petition for juvenile indiscretion. However, if you really look at that document, it's not a background investigation report. A background investigation report under the board's rules, 106 and 108, clearly describes what a background investigation report is supposed to be. The elements were not contained in this document, which was titled Background Investigation Report. But if you look at the document and go through it, what it is a petition for juvenile indiscretion. It addresses the 3 issues that the board had addressed: the participation in the theft of a vehicle, his criminal damage conviction, and the sale, possession of marijuana. And it went through each one individually and said, juvenile indiscretion, things to consider for juvenile indiscretion. What they labeled as a background investigation report didn't meet the board's rule requirements for background investigation report. But it did address all the elements under 105D, showing that it was actually a petition for juvenile indiscretion. At that time, if you look at the transcript, index review 46, there was a discussion about the sale issue, and that they determined it was, go forward, the sale was prohibitive. And
Just
then,
saying, it would have been nicer had the motion been more precise.
well, at the December meeting, the motion was to initiate proceedings to deny. I believe you're talking about the motion when the ALJ's recommendation came back.
That's right.
And actually, in that one, if you look at it, there was some discussion at first. There was a motion that ended up being clarified, where it was based upon the findings and conclusions. They're basically adopting those and upholding the denial. So they were adopting what was in the ALJ's recommendation as the findings of fact, conclusions of law, and they denied based upon the sale. And in that order, again, adopting the ALJ's decision, they found that there was, Mr. Barlow had addressed and found that the board hadn't met its burden regarding participation in theft of a vehicle. That wasn't an issue. They found that his possession, the allegation of possession, met experimentation, exception under 105C. But they found that under the board's applicable statute and rules, that the sale prohibits is disqualifying, and that basically the record established that the sale, and it was grounds to deny. It also went on that experimentation covers use and possession, not sales. The order was clear on that fact. And that because he was over 18 at the time, that juvenile indiscretion didn't apply. The board's order, when they issued the final order of denial, addressed the exception issues, and they denied based on that. Your Honors, the record in this matter supports the board's decision and the Superior Court's decision upholding the board's denial for failing to meet minimum qualifications due to the sale of marijuana. The record in this matter is supported by substantial evidence, and it further shows that the exceptions raised here are not applicable to the conduct at issue. So the state would ask that you affirm the Superior Court's decision upholding the board's denial. Thank you.
Thank you, Counsel. Mr. Barlow, rebuttal.
First of all, in response to his last statement, after the ALJ issued the decision and the board adopted it, on the next hearing, Mr. Hargraves stated to the board on July 18, 2018, that the board denied certification on all three grounds. The motion was for on all three grounds.
And can we affirm on just one?
You can't affirm on just one, but what I'm just saying is, all through this entire, through these proceedings, Mr. Hargraves has changed his argument all the way through, saying that the petitions are not necessary, and then they are necessary, then they weren't filed, and then we do our own determination. He's changing everything all the way through here when the rules are specific that here's your conduct, here's your minimum qualifications, here's your exceptions, and these are how they are supposed to be applied. They apply the waiver. If you turn around and take 103G, which is the public trust in the law enforcement, the ALJ addressed all issues there. And if you go to conclusion of law number 22, it says, because Mr. Barlow's sale of marijuana was a one-time event that was related to his decision not to experiment, that marijuana, and considering Mr. Barlow's relatively young age at the time, this would not jeopardize the public trust. If they turn around and apply 103G, then it is up to their discretion. Well, then it's their discretion on every single thing. It doesn't even matter. The board adopted this, but yet turn around and denied certification without considering the petitions. And if we turn around and write the rules, and once we take in 103G, we don't have to do anything. They don't have to follow anything. They can turn around and really deny anybody on anything. Once they go through a polygraph test and once they go through all the questionnaires, there's one thing in there. Did they drink a can of beer one time? Anything. They can turn around and say, well, that's, you had alcohol. No.
Counsel, I view 103G somewhat differently. Isn't it sort of a shock absorber, safety net, trapdoor, whatever you want to call it, that if otherwise an applicant would be disqualified if there's sort of extraordinary circumstances, using different terms in the reg, that 103G would apply. I don't view it as going the other way, that if somebody qualifies, that
You're correct, but then they just have the discretion to accept anybody. And they can deny anybody.
I think I
I mean,
understand
that's really
your-
all, that's all they
I
have
think
to
I
do.
understand.
And,
Did,
I mean,
did the parties engage before the board on the issue of whether to apply 103G? Was there discussion, advocacy on that point?
not really. I don't believe that was ever brought up at all other than in the Ayla case. His order. One more thing that I would like to address is there's something that is not before the court here, but this is what Post just accepted back in December. It was someone that had taken narcotic drugs over 6 times within 1 year, all within the last 7 years, and they waived him right on through.
But
So they can, and that's not part of it. That's just an example. That's not part of my brief. But what I'm just saying is, if you don't apply the rules, they can just turn around and they don't have to apply them. And because they didn't apply them here, we can just accept to take anybody we want. We can deny anybody we want. And that's what's happened here. Thank you.
Thank you, Counsel. Counsel, we appreciate your briefing. We appreciate your presentation today. We will take the matter under advisement and we'll issue a written ruling in due course. The court will stand in recess. We're going to stay on the bench while the courtroom is set up for our next oral argument. Thank you.